Is that the leaf blower noise in the back? That's a sign of spring. They're getting ready for spring.
I'll mute myself when I'm not talking.
So, Greg, did you froze to death last week, and now the leaf blower guys are out. That's great.
No, it's gorgeous. I biked this morning, and it was already warm enough. I was only in normal.
It was freezing in Atlanta today, and poor Delay. Hello, Delay. How are you today? I'm sure it's still freezing up in Boston, though. So
Chuck, just so you know, I'm going to have to drop at 20 minutes to the hour. I have to drop off.
We're going to be done by then. We're going to be done by 12:30 today.
I'm going to Florida tomorrow, so
I'm going to Aruba tomorrow. I beat you.
Are you really?
Yeah.
I have to go see Ira and go talk and have him tell me about what a greedy son of a bitch I am. So it's not as much. It's not as much fun as I'm making it out. Although I'm talking with Anis, who I love, Anis Soleil. So.
I love Anis Soleil. He's one of my favorite lawyers.
I would not have gone to the chapter conference, but for him.
I haven't been invited since Tammy is no longer in charge. So I used to do the Tammy, Ron, and Chuck show down there. That was always a lot of fun.
Well, Tammy and Ron are still doing their show, but I don't know who the new Chuck is.
Yeah, no, I didn't get invited to that. So, anyway, it's great to be with you guys. I hope you all had a great week. I know I had a great week, and so I'm excited to be here. We want to do our first update today if you guys don't mind, on the Jain EB5 case. Let me find the handy dandy cryon here. So I'm not left out in the cold. I know I have an EB5 cryon here. So the government was originally scheduled, and I don't know why. Oh, that's not it. I'll have to add one. I don't know what's going on. So for the Jain EB5, the government was scheduled to file their motion for summary judgment on Monday. On Thursday, they called me. And they told me one of our plaintiffs has been approved. In fact, Mr. Jain has been approved. So he's gone. I dismissed him from the lawsuit. And two other plaintiffs, one has I think they both had RFEs, but they seemed to me pretty easy RFEs. So that only left us, there's 14 other people. And the government begged me for one more week. And, I gave it to them because I'm not a jackass. And I know they had a long time to get ready for it. But I've always found I have a good working relationship with this lawyer. In return, I begged her to just get everybody's damn case adjudicated, and then the case goes away, because she knows we're going to get discovery. So we extended the deadline out 1 week. So on Monday, her response will be due, and her motion for summary judgment. And then we're preparing right now. We're in the midst of preparing our motion for discovery. And then we'll go from there. So that's where the 14 remaining Jain plaintiffs are. If you're one of the two plaintiffs that got an RFE, I'm begging you, please respond right away. Mr. Jain had the easiest RFE in the world. It took a month to get back to them. So just do it. And if you didn't know you got an RFE, call your lawyer. All right, call your lawyer. So that's our Jain EB5 update.
Speaking of EB5 delays, I have there's a consolidated case in the DC circuit that I'm representing one of the appellants there, and it's based on you know what, someone had to do it, and because what we're seeing is the use of 12b-6 essentially as a rule allowing people courts or a government to dismiss cases, and I believe they're tricking district courts into taking the facts as they see them.
Yes.
And getting courts to dismiss. And it's a very big issue. And so I'm not making this an EB5 appeal. I'm making this Iqbal, Twombly. This is how you plead complaints. You can't just start taking the government's word for it. Because if we don't do that, and I know your Jain case has been successful, and I congratulate IMMPact for that, in the DC court, you can't file a 526 delay right now case. I'm talking 40 months.
You'd be foolish to file it. Yeah. And
absolutely.
This is a 4-year-old case. You can't file it.
But they're good cases. They're not applying the standard. They're being, it's incredible. So,
well, it's leaking into other things too.
Totally.
It's leaking into everything else. So
totally. And I think there's fairly good precedent of appellate courts coming down on their on district courts saying, hey, I understand you're busy, but you can't really skirt the rules. Like, you can't just start kicking cases out.
How can you dismiss something that's pled rationally and factually? It doesn't make any sense to me why these courts keep doing it. I mean, I've read the opinions. I know why they're doing it, but
I can tell you, like in my case, just so everybody knows, I mean, the track factors are the same across most APA delay cases. The court in our case, in my case, and specifically, it's called DaCosta. He found that our plaintiffs had been harmed. He said specifically, track factors 3 and 5, you win, except you lose 3-2. And that to me is merits.
So I agree. That's absolutely merits.
Yeah.
Because there's no discovery. How can you challenge with the government? You don't know that's true.
Well, and the other thing too is, I mean, I don't care who really has to hear this, but track factor 4 on, we have to reshuffle the entire deck.
Oh, that's crap.
Taken to its logical extreme, and courts have done this. That means that you can never win an unreasonable delay case.
Yeah,
right?
Exactly. There's nothing unreasonable.
And so this is really where this all of our cases are heading, right?
Yep.
Is that, they say, take our word for it. In the Etta Cooney case, when we actually, they shot themselves in their own foot because they said too many words, and now we're going to see what happens in our 601A case. But, again, it's really where this law is headed. I mean, the litigation of these delay cases is headed. And I think we need to do a really good job as litigators at making sure that courts do not just say, well, they said so. So you lose.
That is
so you lose.
And, we had a great judge in our EB5 case. I think we still have a really good judge. I still feel confident in getting discovery. And really, it's not the question do we want discovery? No, we want an answer. But if getting discovery makes them do the case, then I don't care. But I'm more than happy to depose the head of the Immigrant Investor Office and find out why they haven't adjudicated cases for 5 freaking years. Somebody needs to ask them the question. All right, so that's it. The next question, the case we want to talk about is our 601A. I'm sorry. Wait, hold on. That's the wrong one. 601 delay litigation with Ayla. And we are currently adding additional plaintiffs. So, Greg, what's our deadline to add folks?
Yesterday. However, the dirty secret is that if somebody gets us quickly, we're still drafting the whatever we're submitting, either a complaint or the amendment, we usually can get somebody in after the deadline. We can't get somebody in like the day we file typically, but we tell people February 6th because our goal is to file it, within a week of within a week of our deadline on there. But what we don't want is for people to give it, start submitting it like the day before we're about to file. That's just too burdensome. Mm-hmm. So anyway, February 6th was the deadline, which means that our goal was to file the amendment next week. And but if you can get it to us like in the next day or two, you should be okay.
Okay, great. So that's kind of where we are. Join us. We're going to win. I know we're going to win this case. I am fully confident.
You can't say that.
I know I can't, but I mean, this is ridiculous. It's ridiculous.
We like our arguments. That's what you say.
I love our arguments. And the reality is the government keeps getting longer. It just keep getting longer.
I'm going to channel my inner Aaron here and say that there's multiple ways we can win. And we hope that the government, Aaron, we hope the government takes one of the exit ramps available to make our plaintiffs at least have the ability to work and live without fear of being removed. That's
the answer. So obvious. It's so obvious. So there you go. We are getting ready to onboard a 601A waiver case for consular processing cases.
Yes. So we have a we're done with the FAQ. We're done with the apps on there. So we just need to go through a little bit of a review. We're doing something different this time on the 601s. We have combined our engagement letter and our declaration generator into one app, so we've taken a step out of the process, and basically you answer all the questions and it will produce both an engagement letter and the declaration in one single document that will be signed in 2 places on there, and hopefully that will make life a little faster and a little easier for everybody. But this is the first time we're doing it that way.
I had a consult yesterday with a woman who needed a 601A waiver because some other lawyer had sent her down to Ciudad Juarez and forgot to ask him how her kids came to the United States. And she'd paid to bring him in. So she's sitting now in Juarez for the next 2.5 years, apart from her kids, waiting for her green card from her husband, who's now desperately trying to figure out how he's going to take care of 2 teenagers by himself for the next 2 years.
I have never believed that you can smuggle your own children.
Yeah.
I know that that's their interpretation, but I just don't believe it.
And I agree.
I wanted to explain in case there's anybody watching who doesn't speak immigration form language, what a 601A is and what a 601 is. So the case that we have pending is a 601A. That's already filed. That's for people who are doing a waiver while they're here in the United States, just for unlawful presence. The new case that we're going to be onboarding is for 601s, which is for people, in this case, it's for people who are outside the United States seeking a waiver of various grounds of inadmissibility. Some of them might be for criminal convictions. Some of them might be for unlawful presence. Some of them might be for smuggler grounds, different kinds. But it's a different case, and it's for people, again, who are outside the United States waiting for these applications to be adjudicated and waiting, like Chuck said, years to be reunited with their families. They're really heartbreaking, these cases.
So there you go. It's an awful thing. And the 601 waiver application is used for a lot of different things. So there you go. Maybe we'll litigate the 212 waiver, which is now 2 years as well, sometime in the future.
I will say, though, I looked into that. The 212, you know what the government has been successful at doing? Arguing that a 212 waiver is associated with the removal order, so it can only be challenged. But if your PFR is I'm way too technical today. I've been doing way too much Lexis. No. But they've said that even if the time is over for you to file a petition for review, you're out of luck. There's nothing you can do, because you can't go around and try to, collaterally attack the removal order. So it's like there's no review. That's a great issue. I'd love to take that issue on, because they're saying essentially that I-212s are not reviewable, the delays. Yeah,
that's insane.
It is insane.
Because they're related to a removal order
under,
what is that provision on the INA 242 or whatever that happens to be.
Yeah, there's some really crazy second.
I can see that in the 11th Circuit, by the way, which is the home of Patel.
Yeah, there's a Second Circuit decision where, they got someone with, they just got duped. The government made that argument, and talking about the shield to judicial review under 242, and they bought it, and every other court who have looked at it without looking closely has kind of bought off on it. But there's an opening. I mean, it's not like it's ironclad or anything, but yeah, we should do it.
Makes me nervous with that, though. All right, we're also getting ready to onboard our prevailing wage delay litigation, which should be up soon. So, part of the problem with prevailing wages at the Department of Labor is we don't know when they're going to get done. Now, we do a lot of prevailing wages. I know some of you, I know Greg's firm does as well. And I know Aaron's firm does too. We had some recently approved that we filed in, I think, June. But we have some from January we don't have. So this is the evidence that the government's not processing cases in time. So we'll get you more information on that. One case we will not be filing is the E2 visa in Bogota, because nobody wants to hire us to do it. So There you go. It's funny because on the listserv,
you can't complain if you won't go to court.
Yeah, you can't complain on no. Nobody won't interview 2 years.
Right.
It's clearly illegal. You can't just refuse to do a certain class of visa. We proved that in the K-1 context, but there you go. And let's just touch base really quick so we can pre-answer the 100 questions we're going to get on Go and Gomez. If I recall once again correctly, that in September we told you 6 months, easy. That's February, March, and and you can't. Now I would ask Jesse. Jesse, can you call up Judge Henderson and ask her what the delay is on the case in issuing the decision here? I don't know.
This is going to sound really bad, but I would first have to tap her on the shoulder and wake her up. I could write her decision, right? You lose because you want to come to this country, right? Yeah. You lose. I think that what people have to understand is, they find a story or a spinster online that tells them that a decision was supposed to issue on X date, and that's just not the case. I mean, I've done a lot of appellate work in my short.
I think people feel like we should be able to file a mandamus against the court.
I think what you have to understand is this is a very hard case, and this is not a slam dunk.
This is cutting edge stuff.
It's a game changer. I mean, this could go to the Supreme Court. It's more. I know. It's really about, hey, I need a visa. I'm in a difficult position. And I wish the Biden administration understood that and actually withdrew its appeal. And they could. So they could make it go away like yesterday. But if they want to press the court, they're going to decide some really novel questions. And it's, the other thing is I haven't counted, but I think there's 5 or 6 cases that have different issues all combined. And we made a big pile. And multiple years are involved. So I can understand the court sitting here passing back and forth an opinion on this case. So I don't think, there is anyone who can tell you when it's going to issue, because I could have issued yesterday. And I think I've said that.
So anyway, we have no ability to influence the decision at this point. Nobody.
But I think the case does illustrate that there's this competition within the Biden administration for pro-immigration versus keeping power. Yes. Their inclination is obviously they like immigrants certainly a lot more than than the last administration, but they like power more. And the State Department, I think, would be willing to take anti-immigrant positions to preserve their power as opposed to the court taking it away from them. So they will go out of their way to take positions that hurt immigrants if it means that they get to keep their power and the court can't tell them what to do.
Yeah, I mean, did you see that that proposal that Joe Biden said to restrict presidential power to ban immigrants again in the future? I didn't see that one because I don't remember when he did that.
That didn't come out.
Under that 212F and the no visa policies and all that. No, they want more. They're asking for more, right?
These are people that believe in the unitary executive. Both parties believe in the unitary executive.
Well, and I guess
the president.
I don't want to say devil's advocate, but to play the executive advocate, what they would say is, hey, just like we're trying to do with this parole, we were trying to kind of preserve our power to not issue diversity visas. And, and what's crazy, though, if I were the judge and I was writing the decision, I would say, you son of a B, if you're telling me you can't issue these visas, last year you actually issued more than you were supposed to. So you broke your own law. So don't tell me that you can't do it because you just did it. And I wish we should file a 28J on that. Honestly,
that's actually not a bad idea to do a 28J on that.
Ugh.
Well, tell them what a 28J is.
Rule 28J of the Federal Rules of Civil Appellate Procedure says a decision related to the facts of the case. Generally, it's a court decision from an equal or higher or related court to notify the court of a change in law, typically. Or fact.
I actually did. I mean, I have other co-counsel on the Gomez case, but I think it's a wonderful idea for the Go team it did not go very far for me. But
the Go team I do think it's important. 28J there.
It's important.
Clearly they think they have the power to do it or not do it. So what's the difference?
It's absolutely about executive authority. Like State Department, it's the same thing with the E2s.
Yep.
Hey, if you want to do E2s in London, that's great. Down here in Bogota, we're just going to watch balloons fly in the sky. That's fine. That's their position. And they're like,
Chinese balloons.
Whatever, red balloons, any balloons. But I mean, that's the position. Like, we get to do what we want. Like, that's crazy.
Oh, man. All right. So there you go. And just a quick update, Senenchenko, the clock's ticking on the government response. We're still waiting to hear back from them. So we'll see what happens. All right. Let's go ahead and answer some questions today. Tim Sankey, in regards to 618 lawsuit, Plato's is the best case scenario, normal case scenario, and worst case scenario. Jesse, you want to take that one, or Aaron, you want to take that one?
I think Aaron and I can, Aaron, I'll take it, and then you can tell me where I'm wrong. Best case scenario is the government would come and they would give everyone work authorization, deferred action, and agree to reduce their processing times back to 6 months. The normal case scenario, there is not going to be anything that's normal here because we're trying to change what they consider to be normal. I think an acceptable case scenario is they say, hey, we're going to do our best to change the times and make them down, but we understand the harms are so great that we're going to give people work authorization and deferred action. The worst case scenario is Judge Lynn tells this is totally normal for the processing times to go from 4 months to 33. Your plaintiffs, 39. Your clients are not suffering any harm. They can sit home and be thrown in jail. And if there's an administration change, nothing bad will happen. Don't worry about it. Go away. That's the worst case scenario.
Yeah, it's not going to happen. It's not.
Times? I don't know what the times
Aaron,
are.
Aaron, what do you want to add to that?
No, I think just on the best case, we missed. I think we missed a part, unless I missed it. It's they come to the table, they agree to return to 6 months processing times, and first they adjudicate all of our named plaintiffs.
That's the key.
Yeah. Well, and also I guess we'll see they can do all this without getting to the class question as far as agreeing to, if they settle with us by adjudicating our plaintiffs and then giving us a 6 month timetable and maybe interim work authorization.
I would think they would test the temperature of the court first, right? They'll probably walk into court and say, "Oh man," they'll see, is Judge Lynn, does she get it? And she does, by the way. She's incredibly bright.
They should know that.
She's an absolute, really rock star judge. And I think they're going to say, okay, what's our upside downside here? And if I were in their shoes, I would pick something that everyone can live with that doesn't give away their power. Yeah.
But they rarely make the right decision, so I guess we'll see.
No one listens to me, I know.
Vulcan, this is an awful, 618, 35 months from Turkey, earthquakes.
Right.
This is the exact kind of reason. Hopefully you're a plaintiff, Vulcan. If you're not, please join as a plaintiff. And if you are a plaintiff, would you update your declaration?
Yeah.
And we will amend that with the filing. That'd be great. We can do that. That'd be great. Ash, good morning. Happy Tuesday. Sorry, tweet H-1B numbers. No, Ash. They have not responded to my FOIA, and I really need to file my FOIA litigation. Jesse, can I hire you to file some FOIA litigation for me?
Yes.
I asked the Immigration Service 2 questions. I didn't even ask for documents. I asked 2 questions. One, how many H-1Bs actually were issued for fiscal year 2022 as of November 30th? And 2, what is the percentage of people, of companies that actually applied for H-1Bs compared to those that have actually registered, that were notified that they won the lottery? They have these, this is information they clearly have. And they're just refusing to answer. I mean, this is literally probably 10-minute answer. I think that'd be a great litigation, Jesse. I'll hire you offline to help me file that. That would be great.
Well, it's not that hard. If you get to 10 days and they don't give you something, they have
I can go to court. I mean, they clearly, and I already appealed, by the way.
That statute is pretty clear.
So what you do is you file an administrative appeal. They wait 10 days, then you can sue. That's where I am. My time is passed. A lot of cases are in front of D.C. Circuit in November, October. Really had their decision in January. They're all three killing the Casas. Well, which way was the 3-0 and what was already argued? The reality is this is a hard case.
Right. If it's a 3-0, it's not going to take as long.
No,
we already told you you're going to get one no.
Yeah. So that's why it's taking long. And I'm so glad that somebody's actually digging through oral arguments from November in the court. Good for you.
Educational.
But there are probably a number of cases from our date or earlier they haven't adjudicated.
Yeah.
It is a sign of dissent because we already updated on. Maybe it was good because Henderson takes on the right of dissent opinion. Well,
I was thinking though, she just got finished writing the dissent for the Wash Tech. Yeah. So I wonder if that. I don't know. I'm totally. I'm
that
doing
was that dissent was interesting in that case.
Yeah, but they have other things to do.
And that's definitely going to SCOTUS. By the way, those people are not going to give up. They're not going to give up. That's going to SCOTUS. Yeah. All right, we already asked that question. Lionel Vidal, did you know that Nebraska went from 34? Oh, there you go. They went up again. I bet you. I think every Monday or Tuesday they update the dates, the time frame. But we know that Potomac is 39 months. So, Paula, put it not before spring. Remember, spring is March 21st in the United States. So, Brittany, when will the people want us to expect to see some movement? Okay, so this is really great. Talk about the timing, Aaron. We filed. What comes next?
Yeah, so what's important for when people might see movement is what kind of happens behind the scenes. Because when we file this complaint, we give information for all named plaintiffs to the government with the complaint. And normally one of the first things that they do, first of all, their first deadline is to respond to a complaint within 60 days. So that's their deadline with the court. That's their obligation with the court. But in the meantime, they usually want to check and see what's going on with all these cases. So they're reaching out to their contacts at the agency at USCIS with the information we've provided as far as names, case numbers, and saying, hey, what's going on with these cases? Can you let us know so that we can, be informed with our communications with the court? And sometimes that leads to the agency, I think, picking up the file, basically, and saying, oh, well, this case is obviously approvable. Let's move it. And so sometimes we start to see numbers pick up for adjudications before their filing deadline. Sometimes it can be after. Sometimes they want to litigate an initial issue first before that. And so there's no guarantee, but sometimes you can see movement in that 60-day period.
Yeah, they'll start picking off the ones that are really hanging out there at 35, 36, 37, for sure.
Yeah, they have to. That's what we see there.
I'm going to be getting the data scraping tool for this case also, so that we'll be able to track sort of.
We'll be able to track it. That's a great idea. That's great. The government in 60 days, of course. What usually happens first is a government lawyer will enter their appearance with the court. And for example, in our Ukraine suit, that occurred within 3 weeks of filing, of being served. And sometimes it's right 60 days. We just don't know. And because we don't know who's going to be assigned the case at this point, we know there's a local government lawyer that's assigned, but that is unlikely to be the government lawyer who actually handles the case. This is a class action lawsuit. Our friends in oil are definitely going to be handling this. Let's see. Latest on DACA? That's a great question. As you know, the 9 states that are currently fighting DACA have filed a motion with the court last Monday, I believe. Aaron, correct me if I'm wrong.
I missed that. What's going on this week?
Yeah, so the 9 states moved for essentially summary judgment against the Biden administration on the DACA. And they argued that DACA should end and be phased out over 2 years. Basically, people's EADs expire, and they just.
How do they do that with the Supreme Court? Basically,
it was sent back to the judge. Whatever that judge, bad dude judge in Tipton, Texas, wherever that is, in the Victoria district, wherever that is. So they filed. The government's filing their response, and I'd likely assume a cross motion for summary judgment. What I've been telling, I don't know what you guys tell your DACA clients, but I tell them, look, if you have had your current DACA and it expires, sometime in the next 18 months, you might want to consider filing an extension. Okay. There's no requirement that you wait to 6 months beforehand. Government doesn't want you to file until 5 months beforehand, but I think that's ridiculous. And if you have a chance to travel and you haven't gotten and you don't have a lawful entry, begging you, do an advance parole. Find your dying grandmother, your sick Tio Raul, or whoever, and go visit them, or get a conference to go to, or go to a study abroad program, but get your legal entry, because you never know what will happen in the future. What I like to tell people is this. I always ask kids on DACA, do you know how many people had DACA at its height? At the most? They said no. I said, it's about 1 million people had DACA at one time, 1 million people. How many people have DACA today? 580,000. What happened to the other 400,000 people? They got green cards. Right. Almost all of them got green cards. How? They traveled. They married citizens. Heck, their kids turned 21, unbelievably. Yes. So do that. I mean, for that, it's been good. I'm not sure student pictures go to the U.S. for almost 3 years of waiting. Yeah, well, I understand. It's really frustrating. Take more time than this issue. Okay, that's a go. Okay, we already answered that. Soon, U.S. will increase prices. They're going to help hire. No. Greg loves mentioning this. We were told in June they're going to be done hiring by when, Greg? When was that going to be?
December.
They'd be fully staffed.
They claim that. The problem on it is it's sort of a moving target, because they're taking about 50% longer on a lot of the cases that they're working on. So presumably getting back to what was adequate staff when they, before they bloated up all their processes, no longer adequate.
Yeah, but think about it. What is adequate? Clearly it wasn't adequate before. The thing is their volume of cases has increased.
Right.
Because of the delays. So now they need more people than they would normally need during a regular flow situation.
Yeah. But when you add all these pages to the I-45 and the I-765 and all these, these run-of-the-mill sort of bread and butter cases that they work on, you need more people if you're going to do that.
Well, and the other thing that's going to happen is they're about to dump a bevy of new regulations in May that are going to affect employment and family-based applications. And, and then the excuse will be, well, the law's changed. We had to retrain people. And, again, they've been talking about how if you just give us more money, we'll do a better job, since I think I was in diapers. So I think I
certainly was a young lawyer when they were talking about
it. Yeah.
Sure.
The reality is, immigration reform is beyond necessary. We don't have anyone in Washington who is championing immigration reform seriously, and we don't have any leadership in the White House behind the issue. And until we do, this is the system we have.
Yeah, but you can't blame it all on Congress, because the agencies have managed. If they had managed themselves a lot better over the last couple of years, they wouldn't be in this position.
Oh no, this is.
I used to be a bureaucrat, so for me, but again, I think, of course, you have kind of the administrative agencies that I say this all the time. They don't get the real world. They're trapped in their own tunnel vision, of life, of the world. They don't see the 601A issue. They don't see that guy who can't work for his child.
No, they
look at it like, I got a ton of work to do.
But that's
also got to go to lunch.
That's also partially because the agencies have shut down the engagement process.
Right.
To this listening
session.
The
liaison process.
And I have to say, this listening session nonsense, where you basically, people, there's not a discussion.
It's a telling session, right?
They don't give you answers.
It's a telling session.
Yeah, no, they need to have regular, ongoing meetings with interested parties.
And if you look at it, listen, in this administration, it was easier under the last administration. It was us against them. They didn't want immigration. Here, we actually have people who we could consider friendly to the process, to visas issuance, to family-based, and they've done certain things. but it's a matter of, and it's not really competence. It's you have a system that doesn't work, and there's not an urgency behind fixing it. There's marginal fixes.
Yep. Well, here's a fix that could work, but it doesn't exist. Premium processing for 601As. Yes, they could have an extortion fee for that as well.
Extortion. That's what I was going to say.
That's what it is. It's extortion, right?
Totally.
At a certain point, it goes
the
from
RFE rate go up
extortion.
about 4,000%.
Yeah. One last question here. When our prevailing wage termination, what is too long? 90 days is too long, I think. Certainly 120. The historical average prior to this administration was 3 to 4 months.
Yeah,
that's acceptable.
I think though that in the I think for the case we were looking at a year. I mean, I forget what the number was. We were looking 4 months. All right.
Yeah.
Well, right. All right. I'll have to go back and look at the epic.
I will say though that the more I've looked into that issue, it's like everything else. I mean, the harm is really circumstance specific, because some people, if they're gonna, it could be catastrophic after 5 months.
They're going to age out. They're going to use up all their age time, and I got no action. Yeah, it's catastrophic. All right, we're done for today. It's great to see you, gentlemen. I know Greg's got to head off here, and we will see you next Tuesday. I'll be live tomorrow at 1:00. Anybody else live this week?
I'm actually doing a Super Bowl Sunday thing with Simon, I think.
That'll be awesome. Please don't.
Yeah, I know we did it last year. Again, I shouldn't say anything during it because I'm a little bit out of the DV 2023 space, but I really want to it's basically like don't sue. That's my.
Well, I feel terrible for those African countries that are being jerked around by state. I mean,
it's unbelievable.
It's unbelievable. All right, you guys have a great week.
Wow.